Okay, so I'm Randy Schmidt. I direct the Employment Law Clinic. The Employment Law Clinic in various iterations has been around so long that I was a student in it after my first year at law school, and it was old then. It was created shortly after Title VII was passed, Title VII of the Civil Rights Act of 1964. Illinois passed its Fair Employment Practices Act shortly after that, and the clinic at that time was getting started doing cases, and the employment cases were one of the cases that we started doing. It's changed a lot in those decades, and so I'm going to describe kind of what it is right at this moment. Maybe different in the fall, maybe the same. And it certainly was a little different than it was like 2 years ago, but here's where we're at right now. So an overview, we're litigation focused. Litigation is different than trial work, right? Trial, you actually go to trial, you get a jury, a judge, whatever you put on witnesses. We're litigation, right? So we do a whole lot of stuff to get ready for trial and then settle. We have one case now that we are ready for trial. It is set for 2 weeks, 2-week federal jury trial in July. We will see if that actually goes forward, but we're litigation focused. We represent individuals. The case is going to go to trial as an individual case, as well as group representation. All of these cases, I say here, they're discrimination cases. That's true. There are some other employee right issues that come up, but most of our cases focus on discrimination in employment. All of our cases right now are in federal court or the Illinois Supreme Court. We have none in front of any of the administrative agencies, but that could change. So I want to talk about our cases in the district court that are getting ready for trial. And in these, there's 3 groups of cases, right? The first are our individual cases. This is where we represent an individual as their attorney, getting ready to try the case, doing discovery, responding to summary judgment, things like that. We have class actions where we represent groups of individuals who believe that they have suffered from some type of discrimination that is that we can sue on as a class. And then recently we started taking appointments in employment cases by the district court. So I'm appointed to represent the client for settlement purposes only. So the students research that case, draft a settlement demand letter, meet with the client. And then this year we had 2 3Ls who were licensed, who actually represented the clients at, I'd like to say, successful, at least at this point, settlement conferences. Okay. In the 7th Circuit in the Illinois Supreme Court, we do a couple different types of cases, right? So in one set of cases in the 7th Circuit, we're recruited or appointed to represent pro se appellants in employment cases. On those cases, the students write the brief and ultimately can argue the case in front of the 7th Circuit. The second type of case is Amicus cases. And in these, we're asked to represent groups from across the Illinois area, as well as national groups, to represent them as their attorneys in a case before both the 7th Circuit or the Illinois Supreme Court. So let me ask you a question. How many of you are getting $397 from Facebook? Only 1, 2? Where were you guys? There was a claim sent out, right? Your rights were violated under the Illinois Biometric Protection Act. Facebook collected your biometric information and without disclosing it. As a result, there was a class action filed. It just recently, the 9th Circuit affirmed the award, and so people are supposed to get $397 soon. We represent groups in amicus briefs arguing about the meaning and the scope of BIPA. So we have two cases right now in the Illinois Supreme Court where we're an amicus arguing that when a cause of action under BIPA accrues, and then what the statute of limitations are. We had a similar case in the Seventh Circuit where we successfully argued that this is an issue that should be certified to the Illinois Supreme Court. In these cases, again, we write the briefs. As an amicus, we normally can't argue, although the Seventh Circuit has been very good in allowing my students to argue as an amicus in 3 cases, 2 this year and 1 prior years. So, all right. Okay, next, I just want to talk about what the clinic experience is. So those are the cases we handle. So students do a variety of litigation tasks. If you hated civil procedure, I'm not sure this is the clinic for you. If you didn't hate civil procedure, I'm not saying loved it, not even saying liked it. If you didn't hate it, then consider it. So we do deposition. Remember the rules about that. We do settlement conferences, as I mentioned. We are we've been fairly successful in the settlements. So this little slide shows a case we settled 2 years ago for $3 million. The list here is Safar Shaw. Every year they put together a list of the top 10 private class action settlements. And so we're number 9 on this list. I don't like to include the Alphabet or Wynn Resorts one, because those, although they were employment class actions, they were really shareholders suing because there was a sexually hostile work environment at the workplace. So you get those out, we move up a couple things. Recently, like December of last year, and then it was just recently approved, we settled a case for $9.25 million against the Chicago Board of Education on behalf of African-American teachers and paraprofessionals. I think it will make the top 10 on next year's Safar's list. If it was on this year's, it would have been between a $10 million settlement and an 8. So I think we would have been like 7th or 8th. So, all right, so we do these settlements. We have client interaction, both in terms of getting clients ready for depositions, getting ready for trial, the settlement conferences, and other things. I talked about the oral argument in the Seventh Circuit. Modern litigation is a lot of discovery than summary judgment. So every one of our cases we face and have to respond to motions for summary judgment. We've been pretty good. Can't say we win them 100%, but we usually at least survive on one claim, and that will lead to ultimately a trial, which makes people real serious about settlement. We also, in these class actions, have to brief class certification, and then if it's denied, do the appeal to the Seventh Circuit if we can. And then I talked about brief writing in terms of the amicus briefs and the briefs on the merits in this Seventh Circuit Illinois Supreme Court. We also write briefs on summary judgment, motions to dismiss. We write these very long settlement demand letters in the settlement conferences. And then last, we work a lot with co-counsel, whether they're actually our co-counsel like this pleading that I'm showing you, or we're working with the attorneys for these groups that we're going to do the amicus brief on behalf of. We're constantly working with other attorneys in this area as we're doing our work. All right, so that's the clinic. So now I'll end this. So again, I want to emphasize what Professor Konski said. You should join a clinic, even if it's not our clinic, join a clinic. I was recently talking to the class of '82, and they're 40 years out of law school, and they were all saying that the clinic was the best experience they had in law school 40 years later. So I encourage you to do a clinic, even if it's not mine. All right, thank you.